No law requires the phone companies to store this information in the first place. The information is stored solely at the discretion of the phone company. There's nothing that requires them to maintain it for any particular period of time, and there's nothing that requires them to store this information in the first place.
There's no law that requires this? There's no law that requires the companies to keep this information?
No, there's not. They do it at their own discretion. It's entirely up to them. If a company wanted to not store this information at all for calls, that would be entirely appropriate to do so. We're getting only information which is stored at the discretion of the phone company. And so the records are the company's own observations regarding its own service, made and kept at its own discretion of its own equipment that's used to process a call. I want to make two primary points about this kind of information and why it does not violate the Fourth Amendment when we use a 2703D order to obtain this information. First, there's no reasonable expectation. A customer has no reasonable expectation of privacy in this information under the reasoning of Smith v. Maryland and United States v. Miller. Second, in this case, because these business records made solely at the discretion of the phone company's role here is really that of a prospective witness. That is, someone who, acting entirely on their own, has made observations which are relevant and material to a criminal investigation. And the long tradition for these cases is that the government has the right to every person's evidence when it's relevant to a criminal investigation when the government asks for it in response to lawful compulsory process. And such information, the scope of the information the government can get is judged based on a reasonableness standard. That is, the information has to be relevant to an investigation and not overly burdensome on the provider. And but there's no rule that the scope of information the government can obtain is somehow limited by the interest of the subject of the investigation.
It's my understanding that the magistrate found that you had established the statutory predicate for getting an order within his discretion, but he didn't deal with that, and he simply declared this statute unconstitutional.
That's correct, Your Honor. The magistrate judge found that we had met the specific and articulable facts statutory standard, but held that that statute violated the Constitution, and that ruling was affirmed by the district court.
If we were to disagree with his constitutionality ruling, would we have to reach that? We'd have to decide that constitutional issue, or could we avoid deciding the constitutional issue and say that he shouldn't have reached it and under the statute remand it back to him to exercise his discretion?
Your Honor, we believe that when the government satisfies the standards of Section 2703, it's mandatory that the magistrate judge issue a 2703D order.
But if we disagree with you on that, and we disagree with him on his constitutional ruling, would it be appropriate for us to send this case back and order him to exercise his discretion under the statute based on your showing?